Hey y'all, this is video 2 of the documents that were released on January 30th, 2025. I'm reading them in order. So this is the second to last document. I did think there was 3 more. It appears that I had 2 copies of the very last document. So this one is the state of Florida as the plaintiff versus Stephen Michael Stearns. It is a motion to declare statute 9211416M unconstitutional facially and as applied, victim vulnerable due to age, disability, or familial or custodial authority. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned attorney, and requests this honorable court to enter an order declaring statute 921.1416M Florida statutes unconstitutional and to preclude its application in this cause, statutes, and or the 6M jury instruction unconstitutional, and precluding their application in this case, and as grounds would state as follows. Number 1. Statute 921.1416 Florida statute sets out the aggravating circumstances that may be considered in determining whether or not to impose the death penalty in a first-degree murder case. It provides in pertinent part 6 aggravating circumstances. Aggravating circumstances shall be limited to the following. M. The victim of the capital felony was particularly vulnerable due to advanced age or disability, or because the defendant stood in a position of familial or custodial authority over the victim. This aggravating circumstance, they cite Laws of Florida 96 through 290, effective May 30th, 1996, and Laws of Florida 96 through 302, effective October 1st, 1996, will be unconstitutionally applied in a manner inconsistent with its legislative purpose. It is unconstitutionally vague and overboard, and not capable of constitutionally adequate narrowing construction, and as such will be applied in an arbitrary and inconsistent manner. Number 2, because this unconstitutional circumstance will be used as a basis for imposing death sentence in this state, because it makes proportionality review arbitrary, and because its bare terms are all that are required to be read to sentencing juries, there being no separate and corresponding jury instruction that in any way narrows or explains its terms. It as a whole is unconstitutional. See Espinoza versus Florida, Maynard versus Cartwright. That was of 1988. Number 3. Statute 921.1416M Florida statute and the death penalty as applied in Florida violate the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Section 9, 16, 17, 21, and 22 of the Florida Constitution for the reasons set forth more fully below. Number 4, this is a capital case in which the prosecution is asking this court to impose the death penalty. Accordingly, heightened standards of due process apply. See Elridge versus State, 1977. Heightened standard of review, Mills versus Maryland, 1988. In reviewing death sentences, the court has demanded even greater certainty that the jury's conclusions rested on proper grounds. Profit versus Wainwright, from 1982. Reliability in the fact-finding aspect of sentencing has been a cornerstone of the Supreme Court's death penalty decisions. And Beck versus Alabama from 1988, same principles apply to guilt determination. Where a defendant's life is at stake, the court has been particularly sensitive to ensure that every safeguard is observed. They cite Gregg versus Georgia from 1976, polarity opinion citing cases. We're at number 5. A death penalty statute is unconstitutional if it has standards that are, quote, so vague that they would fail to adequately channel the sentencing decision patterns of juries. They cite Godfrey versus Georgia from 1980. Polarity opinion. A capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. They cite Porter versus State from 1990, Owenfield versus Phelps from 1988, Zant versus Stevens from 1993. Now we're at number 6, statute 775.0211 Florida statute sets out the rule for constructing provisions of the Florida Criminal Code. The provisions of this code and offenses defined by other statutes shall be strictly construed. When the language is susceptible to differing constructions, it shall be construed most favorably to the accused. Emphasis added. 7. This principle of strict construction is not merely a maximum of statutory interpretation, it is rooted in fundamental principles of due process. They cite Dunn versus United States from 1979. The rule is rooted in fundamental principles of due process, which mandate that no individual be forced to speculate at peril of indictment whether his conduct is prohibited. Thus, to ensure that a legislator speaks with special clarity when making the boundaries of criminal conduct, courts must decline to impose punishment for actions that are not, quote, plainly and unmistakably, unquote, prescribed, unquote. The principle of the strict construction of penal laws applies not only to interpretations of the substantive ambient of criminal prohibitions, but also to the penalties they impose. They cite Bofuco versus United States from 1980. It also applies to Florida capital proceedings. They cite Trotter versus State from 1990. The terms of this circumstance are so vague and ambiguous that they fail to channel or guide the senator's discretion in order to minimize arbitrary and capricious action in violation of the Florida and United States constitutions. 8. The Eighth Amendment requires that aggravating circumstances, quote, must be construed to permit the senator to make a principled decision between those who deserve the death penalty and those who do not. They cite Lewis versus Jeffers from 1990. We are now at number 9. Great care is needed in both the drafting and construing aggravating circumstances. In rejecting Oklahoma's argument that aggravating circumstance statute was not unconstitutionally vague because there were circumstances that, quote, any reasonable person would recognize as covered by this statute, unquote, the United States Supreme Court in Maryland versus Cartwright from 1998 wrote, the difficulty with the state's argument is that it presents a due process clause approach to vagueness and fails to recognize the rationale of our cases construing and applying the Eighth Amendment. Objections to vagueness under the due process clause rest on the lack of notice and hence may be overcome in any specific case where reasonable persons would know that their conduct is at risk. Vagueness challenges to statutes not threatening First Amendment interest are examined in light of the facts of the case at hand. The statute is judged on an as-applied basis, citing claims of vagueness directed at aggravating circumstances defined in capital punishment statutes are analyzed under the Eighth Amendment and characteristically assert that the challenged provision fails adequately to inform juries what they must find to impose the death penalty, and as a result leaves them and appellate courts with the kind of open-ended discretion which was held invalid in Furman versus Georgia. Emphasis added. Now we're at number 10. The specific aggravating factor at issue in Maynard and found unconstitutionally vague in the way it was explained to a jury, the jury is the senator in Oklahoma, was Oklahoma's version of, quote, heinous, atrocious, and cruel, unquote. At the time, Florida's version of this aggravating factor, statute 921.1416H, and jury instruction were virtually identical with Oklahoma's. And they have a 1 as the footnote. That states, statute 921.1416.8 Florida statute reads as follows. The capital felony was especially heinous, atrocious, or cruel. However, as a result of the Maynard decision, Florida substantially amended its jury instruction with respect to this aggravator to better inform juries of what they must find to impose a death penalty. In 1992, the defendant challenged the sufficiency of Florida's jury instruction on especially heinous, atrocious, or cruel, as it existed at the time of his trial and sentencing. See footnote 1 above. And again, that reads, Statute 921.1416H, Florida statute reads as follows. The capital felony was especially heinous, atrocious, or cruel. In Standard Jury Instruction Criminal Cases number 90 through 1579 SO2D75, Florida, 1990, your Committee on Standard Jury Instructions Criminal recommends that the Florida Bar be authorized to publish an amendment to Florida Standard Jury Instruction in criminal cases. The amendment changes the wording of paragraph 8 on page 79 of the Jury Instruction Manual as follows. 8. The crime for which the defendant is to be sentenced. Let me show you where I'm reading. It's at the bottom. 8. The crime for which the defendant is to be sentenced was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime in Espinoza versus Florida intended to be included as heinous, atrocious, or cruel is when accompanied by additional acts that show that the crime was senseless or pitiless and was unnecessarily torturous to the victim. The committee has decided that the additional language, which is based on State versus Dixon from 1973, improves the instruction and that it adequately addresses any problem the paragraph may present in light of Maynard versus Cartwright, 1988, emphasis added. I think that was one footnote. I did not see it reference number 8 in this reading. So we're back up at the top. We're at Espinoza right here because right here is where it says see footnote 1 above. So I'm continuing from right here. Espinoza at the address. In finding for the defendant and reversing the Florida statute court's opinion that affirmed his death sentence, the United States Supreme Court held that our cases established that in a state where the sentencer weighs aggravating and mitigating circumstances, the weighing of an invalid aggravating circumstance violates the Eighth Amendment. Citations omitted. Our cases further established that an aggravating circumstance is invalid in this sense if its description is so vague as to leave the sentencer without significant guidance for determining the presence or absence of the factor. Citations omitted. We have held instructions more specific and elaborate than the one given in the instant case unconstitutionally vague. See Shell versus Mississippi in 1990, Maynard versus Cartwright in 1988, Godfrey versus Georgia in 1980, emphasis added. So saying and finding that the Florida requirement to the trial jury give the jury's recommendation, quote, great weight, unquote, involved the jury sufficiently as being a sentencer that the instruction to the jury with respect to aggravating circumstances must provide such, quote, sufficient guidance. The court reversed the Florida Supreme Court and remanded the case for proceedings consistent with the court's opinion. We read that a few minutes ago, so now we're at number 12. The aggravating circumstance at issue reads, M. The victim of the capital felony was particularly vulnerable due to advanced age or disability, or because the defendant stood in a position of familial or custodial authority over the victim. There being no standard jury instructions yet promulgated to guide either the judge or jury in the application of this aggravating circumstance, and no judicial decisions interpreting it from which such jury instructions could be drafted, there is no guidance for the sentencer except the vague and ambiguous language of the statute itself. 13. Thus, while it appears relatively clear that the gravamen of this aggravating circumstance is that the victim was, quote, particularly vulnerable, unquote, it is in no way clear how a judge or jury is to be guided in determining the presence or absence of such a factor. Even the word, quote, particularly, modifying, quote, vulnerable, is open to varying interpretations and value judgments. For example, Webster's 2 New College Dictionary from 1995 variously defines particularly as separate and distinct from others, specific or worthy of note, exceptional, encompassing some but not all of a class or group especially, unquote. 14. The entirely logical question, but one the statute does not answer, is, as used in the statute, is a victim automatically, quote, particularly vulnerable, unquote, merely if that victim meets the also vague criteria, none of which are defined, of advanced age or disability, or because the defendant stood in a position of familial or custodial authority over that victim? Or are these characteristics which the jury is to weigh in determining whether or not the victim was in fact particularly vulnerable? We're at number 15 now. The oft used but obviously relative term, quote, advanced, modifying age, unquote, cannot be considered anything but vague without an explanatory context. According to Webster's 2 New College Dictionary 1995, quote, advanced, unquote, is defined as, quote, far along in course or age, unquote. But the statute fails to define the frame or reference to which or whom the victim's age is to be compared. Without any context or point of reference, this term is clearly and only a relative term, having no clear or precise meaning or understanding, and wholly dependent on either one's individual point of view or some further guidelines, which in this case are missing. 16. Members of a capital sentencing jury without additional sufficient guidance could decide what this language means depending on any number of arbitrary open-ended factors. Jurors in their 20s might regard a victim in his or her 50s as being at an advanced age, whereas jurors in their 50s or 60s would be unlikely to agree. 17. The term disability is equally vague and indeterminate in meaning, running the gamut for persons who are totally paralyzed to persons who have chronic back pain. Despite the vagueness of this statute's term, the legislator is capable of adequately defining important terms for the purpose criminal liability. For example, compare the far more precise definitions of, quote, disabled adult, unquote, and, quote, elderly person, unquote, found in Statute 415.102, Florida Statute, concerning offenses against disabled and elderly persons. And they cite 2 as the footnote. 2 says at the bottom down here, disabled adult means person 18 years of age or older who suffers from a condition of physical or mental incapacitation due to a developmental disability, organic brain damage, or mental illness, or who has one or more physical mental limitations that substantially restrict the ability to perform the normal activities of daily living. That's Statute 415.102, 10 of Florida Statute. Quote, elderly person means a person 60 years of age or older who is suffering from the infirmities of aging as manifested by advanced age or organic brain damage or other physical, mental, or emotional dysfunctioning to the extent that the ability of the person to provide adequately for the person's own care or protection is impaired. Statute 415.102, number 11 of Florida Statute. Okay, now we're back up here. We're right here after this number 2. Okay, I want to make sure you can see the mouse. This number 2 right here at the top, we're right here beside it. These terms were actually incorporated in the amendment to Statute 921.1416D, Laws of Florida 96 through 302, effective October 1st, 1996, which expanded the definition of felony murder by adding the, quote, abuse of an elderly person or disabled adult, unquote, to the list of felonies which can be used to aggravate a first-degree murder. 18. However, in the literally life and death matter of this aggravating circumstance found in Statute 921.1416M, the statute's terms are left without definition and are therefore utterly vague and ambiguous. Number 19. The Florida court has recently acknowledged in a case which the cold, calculated, and premeditated statutory aggravating circumstances, Statute 921.1416I, and they have a 3 right here, So we need to go down to the bottom and look at footnote number 3. Footnote number 3 says the capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Now we're going back up. Okay, that 3 was right here, so we're right here. Was found to require further narrowing and limiting explanation to the jury instructions in order to eliminate that statute's unconstitutional vagueness that a vagueness challenge to an aggravating circumstance will be upheld if the provision fails to adequately inform juries what they must find to recommend the death penalty, and as a result leaves the jury and the appellate courts with the kind of open-ended discretion which was held invalid in Furman versus Georgia from 1972, Maynard versus Cartwright from, I'm not sure, Jackson versus State from 1994. We're at number 20. Thus, despite the fact that the, quote, cold, calculated, premeditated, unquote, further noted as CCP, aggravating circumstance and its former standard instruction, which merely mirrored the language of the statute, has withstood earlier challenges based on vagueness. See Brown versus State from 1990. Guided by the United Supreme Court's decisions in Maynard, Espinoza versus Florida, 1992, and Hodges versus Florida, 1992, which had remanded consideration of the constitutionality of the CCP, or cold, calculated, premeditated aggravator, in the light of the court's decision in Espinoza. In Jackson, the Florida Supreme Court held that the various judicial precedents and limiting interpretations of the CCP, or cold, calculated, premeditated aggravator, call for more expansive instructions to give content to the CCP, or cold, calculated, premeditated aggravating factor, footnote omitted. Otherwise, the jury is likely to apply CCP, cold, calculated, premeditated, in an arbitrary manner, which is the defect cited by the United States Supreme Court in striking down HAC, the heinous, atrocious, and cruel aggravator instructions, citation omitted. For all these reasons, Florida's standard CCP jury instruction suffers the same constitutional infirmity as the HAC, or heinous, atrocious, and cruel type instructions, which the United States Supreme Court found lacking in Espinoza, Maynard, and Godfrey. The description of the CCP aggravator is, quote, so vague as to leave the sentencer without sufficient guidance for determining the presence or absence of the factor. Espinoza, emphasis added. Jackson, Serpa at 90. Number 22. Nevertheless, when faced squarely with the issue of whether or not the Florida statute on HAC, or heinous, atrocious, and cruel, and its corresponding jury instruction, which, like the instruction on CCP, cold, calculated, premeditated, and Jackson, simply mirrored the statute, see Espinoza, the capital felony was especially heinous, atrocious, or cruel. They cite Florida Statute 921.14168, Florida Statute. The United States Supreme Court held that, quote, instructions more specific and elaborate, quote, than Florida's were unconstitutionally vague. They cite Espinoza. Number 23. The language of Section 921.1416M suffers from the same constitutional infirmity as do the Florida statutes and jury instructions found unconstitutionally vague in Jackson, cold, calculated, premeditated, and Espinoza, heinous, atrocious, or cruel. 24. As alluded to previously in discussing Maynard, a capital sentencing scheme and a particular statutory aggravating circumstance cannot be saved from unconstitutional vagueness by the fact that there are some circumstances, perhaps even present in a particular case, that could be said to fall within the statutory language. The United States Supreme Court specifically considered and rejected such an argument in Maynard versus Cartwright from 1988, The court noted that a statute might be sufficient to withstand due process challenge, but not a challenge under the Eighth Amendment. Claims of vagueness directed at aggravating circumstances defined in capital punishment statutes are analyzed under the Eighth Amendment and characteristically assert that the challenged provision fails adequately to inform juries what they must find to impose the death penalty, and as a result leaves them and appellate courts with the kind of open-ended discretion which was held invalid in Furman versus Georgia from 1972. We are at number 25. As was pointed out in Jackson versus State from 1994, citing Maynard, the heinous, atrocious, cruel type instructions, which merely mirrored the obviously equally vague statute, are unconstitutionally vague because, quote, an ordinary person could honestly believe that every unjustified, intentional taking of human life is, quote, especially heinous, unquote. Jackson at 89. 26. With respect to the vagueness of the cold calculated premeditated statute and jury instructions as it existed at the time, Jackson held that the unconstitutional vagueness was demonstrated by the fact that it would also be reasonable for the general public to consider premeditated first-degree murder as, quote, cold-blooded murder, unquote, without legal guidance. The average juror may automatically characterize all premeditated murder as cold calculated premeditated. Yet the jury receives no instruction to illuminate the meaning of the terms, quote, cold, quote, calculated, or, quote, premeditated, unquote. Jackson at 89. We're at number 27. Applying the same reasoning and logic to Statute 921.1416M, the above-named defendant asserts that it is unconstitutionally vague and a violation of the 6th, 8th, and 14th Amendments of the United States Constitution and Article I, Section 2, 9, 16, 17, and 22 of the Florida Constitution, because without additional legal guidance, the average juror may automatically characterize a victim as, quote, particularly vulnerable, unquote, whatever that means, merely because of, quote, advanced age or disability, unquote. On the other hand, another, quote, average juror, unquote, may understand that the section to mean that only, quote, advanced age, quote, and, quote, disability, unquote, are the two factors they are to consider in determining whether or not the victim was in fact, quote, particularly vulnerable, unquote. We are at 28. The terms, quote, advanced age, unquote, and, quote, disability, unquote, as well as, quote, in a position of familial or custodial authority, unquote, are clearly open-ended and entirely relative terms to which no two, quote, average jurors, unquote, would be likely to give the same interpretation. Such terms are totally inadequate to, quote, inform juries of what they must find to impose the death penalty, unquote, and thus leave a jury with the open-ended discretion found invalid when applied to the death penalty in Furman versus Georgia from 1972. See also Maynard versus Cartwright. Number 29, the statute enacted by the legislator, Statute 921.1416M, is too vague to pass constitutional muster as part of a capital sentencing scheme. Maynard and Espinoza, Serpa, the legislator cannot, due to the separation of powers set forth by Article 2, Section 3 of the Florida Constitution and the Florida Supreme Court's control of practice and procedure in the court's Article V, Section 2A of the Florida Constitution, enact or promulgate, Promulgate, a jury instruction which might cure the deficiency of the statute. We are at number 30. The Florida Supreme Court has not yet authored a jury instruction that provides a jury with sufficient guidance to render the statute constitutional and has rendered no opinions interpreting, limiting, or explaining the otherwise vague language of the statute. such that a trial court would utilize to interpret or explain to a jury what it must find in order to impose the death penalty based in whole or in part on statute 921.1416M, see State versus Hootman from 1998. 31. Thus, the unconstitutional vagueness and overbreadth of statute 921.1416M cannot be remedied in this court, and this statute cannot be constitutionally applied to the above named defendant. To apply it to him in its present form would violate his federal constitutional rights under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and state constitutional rights under Article 1, Sections 2, 9, 16, 17, 21, and 22 of the Florida Constitution. Failure to limit this aggravating circumstance to situations in which the age, disability, or subordinate position of the victim has a nexus to the capital felony violates due process under both state and federal constitutions. We're at number 32. In discussing constitutionally under due process considerations of the, quote, cold, calculated, and premeditated, unquote, aggravating factor found in statute 921.1416I in Porter versus State, 56 SO 2D 1060 1063 through 64, Florida, 1990, the Florida Supreme Court wrote, to avoid arbitrary and capricious punishment, this aggravating circumstance, quote, must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder, unquote. They cite Zant versus Stevens from 1983, footnote omitted. Number 33. The above-named defendant submits that because of this failure of the legislator to require any sort of nexus, a defendant's actions or motivation in committing the capital felony and this factor, statute 921.1416M, fails to meet the requirement that an aggravating circumstance, quote, reasonably justify the imposition of a more severe sentence, unquote, as required by Zant versus Stevens, SERPA. We are now at 34. Each of the other statutory aggravating circumstances based on the facts and circumstances of the crime, as opposed to those based on the defendant's criminal history, such as statute 921.1416A, the defendant was under a sentence of imprisonment or on community control, or statute 921.1416B, the defendant has previously been convicted of an offense involving violence, and which has been in effect long enough to have been tested for its constitutionality, requires, in accordance with the constitutional principles enucleated in Porter, that there be a nexus between the intentional acts of the defendant and the nature of the crime in order to justify the imposition of a more severe penalty of death. Number 35. Thus, subsection 6C of statute 921.141 requires that a defendant knowingly, emphasis on knowingly, create a great risk of death to many persons. Section 6D requires the defendant to have been engaged in, emphasis on engaged in, the commission of another specific felony. Subsection 6E requires that the capital felony be done for the purpose of, emphasis on for the purpose of, avoiding arrest or effecting an escape. Subsection 6F requires that the capital felony be committed for pecuniary gain, emphasis on committed for pecuniary. Subsection 6G requires that the capital felony be committed to disrupt, emphasis on committed to disrupt, a governmental function. Subsection 6H requires the murder to have been committed in an especially heinous, atrocious, or cruel manner, and requires, emphasis on and requires, detailed jury instruction to limit such cases to only those that were accompanied by additional acts to show that the crime was consenseless or pitiless and was unnecessarily torturous to the victim. There's emphasis on accompanied by additional acts that show that the crime was consenseless or pitiless and was unnecessarily torturous to the victim. Subsection 6I requires the murder to have been cold, calculated, and premeditated, and without any pretense of moral or legal justification. Emphasis on without any pretense of moral or legal justification, and also requires elaborate jury instructions that explain that not only the heightened, emphasis on heightened, level of premeditation required, but that there have been cool reflection, emphasis on cool reflection, and a careful plan or prearranged design, emphasis on careful plan or prearranged design, to kill. Subsection 6J requires not only that the victim be a law enforcement officer, but also that the law enforcement officer be engaged in the performance of duty, emphasis on engaged in the performance of duty, before this aggravating factor applies. And subsection 6K requires not only that the victim be a public official, but that the motive for the capital felony was related in whole or part to the victim's official capacity. Emphasis on the motive for the capital felony was related in whole or in part to the victim's official capacity. 36. Number 36. In obvious and stark contrast, the aggravating factor enacted in section 921.1416M, that the victim of the capital felony was particularly vulnerable due to advanced age or disability, or because the defendant stood in a position of familial or custodial authority over the victim, is completely unrelated to any specific action, intention, or motive of the defendant. Its applicability to any case and to any particular defendant may be totally fortuitous and totally beyond the control of the above named defendant. It will therefore be inevitably and routinely applied in an utterly arbitrary and capricious manner, independent either of the defendant's criminal background or moral capability and blameworthiness, and will thus violate the above named defendant's right of due process under both United States and Florida Constitution. See Woodson versus North Carolina from 1976, automatic application of statutory aggravating factor that fails to allow particularized consideration of relevant aspects of defendant's character and record is unconstitutional. Failure to provide a meaningful nexus between the aggravating circumstance and the defendant or the nature of the crime denies equal protection. 37. Not only will the inevitability, arbitrary, and capricious application of section 912.1416M violate the federal and state constitutional due process provisions, as well as provisions against cruel and unusual punishment, it will also violate the above named defendant's right to equal protection, because there is no nexus between this aggravating factor and anything but the characteristics of the victim. Two defendants with virtually identical backgrounds who commit virtually identical crimes will be treated differently. Number 38. For example, two neighbors, neither with any prior criminal record, get into an argument, exchange threats to kill one another, and one shoots and kills the other. Which is the death penalty case? In one case, the victim was a healthy 50-year-old man and thus probably, emphasis on probably, not, quote, particularly vulnerable due to advanced age or disability, unquote. Thus, with no aggravating factors, the death penalty is not applicable. See State versus Dixon from 1973. In the other case, the victim is 80, and perhaps so is the defendant. Nevertheless, the death penalty may be applied in this case because there is one aggravating factor. See Dixon, SERPA. And because there is at least one aggravating factor, the state may also introduce, quote, victim impact, unquote, evidence pursuant to statute 921.1418. Thus, for committing virtually the same offense, two defendants with identical backgrounds for death penalty applicability purposes can be treated very differently. One legally subject to and facing the death penalty and, quote, victim impact, unquote, evidence, and the other not even eligible for this ultimate penalty. We're now at 39. In Tillman versus State from 1991, the Florida Supreme Court held that Florida's prohibition against cruel or unusual, emphasis on or unusual, punishment as set forth in Article 1, Statute 17 of the Florida Constitution would be violated if death were imposed, quote, based on facts similar to those in cases which the death penalty was previously deemed improper, unquote, because such a death sentence would be, quote, clearly unusual, unquote. They cite Tillman at 169. 40. The reason and constitutional infirmity in the denial of equal protection is that the vague and overboard aggravating factor at issue is related to neither the defendant nor the crime, and therefore does not reasonably justify the imposition of a more severe punishment in one case rather than the other. 41. Failure to grant the foregoing motion would be in violation of the Due Process Clause of the United States Constitution, as well as amendments, and they give Roman numerals, to the United States Constitution, as well as Article 1, Sections 2, 9, 16, 21, and 23 of the Florida State Constitution. Wherefore, the above-named defendant respectfully requests this honorable court to enter an order, 1, declaring Statute 921.141 and or Statute 921.1416M, Florida statute, unconstitutional and preclude their application at bar, or grant such other relief as is appropriate. Whoo-wee! And the rest of that document is just signatures and certificate of service. Let's pull up this last document. All right, this document is the state of Florida as the plaintiff versus Stephen Michael Stearns, the defendant. Motion in limine regarding penalty closing arguments. The defendant, Stephen Michael Stearns, moves this court in limine for a ruling directing the state to refrain from making improper comments in penalty phase closing argument. Well, sir, Lord Jesus. As the Florida Supreme Court has stated, improper prosecutorial comments and closing arguments may be grounds for disciplinary sanctions. We are deeply disturbed as a court by continuing violations of prosecutorial duty, propriety, and restraint. We have recently addressed incidents of prosecutorial misconduct in several death penalty cases. As a court, we are constitutionally charged not only with appellate review, but also, quote, to regulate the discipline of persons admitted, unquote, to the practice of law. This court considers this sort of prosecutorial misconduct to be grounds for appropriate disciplinary proceedings. It ill becomes those who represent the state in the application of its lawful penalties to themselves ignore the precepts of their profession and their office. They cite Ballarati versus State from 1985. See also Campbell versus State from 1996. Some examples of improper prosecutorial arguments are invocation of religious authority or biblical reference, invocation of a higher authority than the law. They cite Farina versus the State in 2006. Injecting the juror's own fear or emotion, King versus State from 1993. Admonishing the jurors that, quote, they would be cooperating with evil and would themselves be involved in evil just like, unquote, the defendant by not voting for death. See King versus State from 1993. Sending a message to the community, deterrence that the defendant cannot be, quote, walking down the street and gunning people down, unquote. Guerin versus State from 1988. The golden rule, imagine the pain the victim felt as she drags herself to the bedroom away from the defendant. That was Guerin versus State from 1988. Golden rule, by putting his own imaginary words in the victim's mouth, i.e., quote, don't hurt me, take my money, take my jewelry, don't hurt me, unquote. The prosecutor was apparently trying to, quote, unduly create, arouse, and inflame the sympathy, prejudice, and passions of the jury to the detriment of the accused, unquote. That was Urban versus State from 1998, citations omitted. Misstatement of the law, when aggravating factors outnumber mitigating circumstances, death is appropriate, Guerin versus State, 1988. Misstatement of law, duty as jurors to return verdict for death, Guerin versus State from 1988. Arguments that, quote, if the victim were here, she would want the defendant to be punished for what he did, unquote, Guerin versus State from 1988. We're right here. Inviting the jury to disregard the law. If defendant was sentenced to life in prison, he could still be released someday because, quote, we all know in the past laws have changed and we all know that in the future laws can change, unquote. Urban versus State from 1988. Arguing that any juror's vote for a life sentence would violate the jury's duty, Quote, my concern is that some of you may be tempted to take the easy way out, to not weigh the aggravating circumstances and the mitigating circumstances and not want to fully carry out your responsibility and just vote for life. Unquote. That was Urban versus State in 1988. Duty to impose death. Quote, I'm going to ask you not to be swayed by pity or sympathy. I'm going to ask you what pity, what sympathy, what mercy did the defendant show to the victim? I'm going to ask you to follow the law. I'm going to ask you to do your duty. Unquote. That was Urban versus State from 1998 and Brooks versus State in 2000. Attacking mitigation as excuses or justification. Quote, prosecutors attacked on Urban's mother as the, quote, mistress of excuses, unquote, and more importantly, his criticism of her because, quote, she never once tried to express concern that remorse, that sorrow to the family of the victim was likewise improper. They cite Shaletto versus State from 1997, Colina versus State from 1990. These attacks could only serve to prejudice Urban for any animosity that may have been aroused in the jury for Urban's mother, hence initially turning the substantial mitigation of parental neglect against Urban, unquote, and that's Urban versus State from 1998. Attacking mitigation as an excuse or justification. Quote, every single thing that was presented to you in mitigation, which I really think was one thing, stretched it out to make it more, but it's one. It's an excuse, unquote. That was Del Hall versus State in 2012. See Frankie versus State from 2011, holding that denigrating mitigation as, quote, make-believe is improper. Arguing against mercy, quote, if you are tempted to show this defendant mercy, if you are tempted to show him pity, I'm going to ask you to do this. Show him the same amount of mercy, the same amount of pity that he showed the victim on September 1st, 1995. And that was none, unquote. This line of argument is blatantly impermissible under Rhodes versus State from 1989. Finding some mercy argument improper because it was finding same mercy argument improper because it was an unnecessary appeal to the sympathies of the jurors calculated to influence their sentencing recommendation. And Richardson versus State from 1992, finding error where a prosecutor asked jury to show defendant, quote, as much pity as he showed his victim, unquote. That was Urban versus State from 1998. Message to the defendant of a life sentence. Now this defendant wants a life sentence for robbing somebody and murdering them. What kind of message would that send? What kind of message would a life recommendation send this defendant? As we stated, these considerations are outside the scope of the jury deliberation, and their injection violates the prosecutor's duty to seek justice, not merely, quote, win a death recommendation. They cite Bertoloni, Campbell, Urban versus State from 1998. Comparing defendant to others more worthy, personalizing the prosecutor. Quote, this blatant appeal to jurors' emotions was improper for a number of reasons. It personalized the prosecutor in the eyes of the jury and gained sympathy from the prosecutor and her family. It contrasted the defendant, who at that point had been convicted of murder, unfavorably with the prosecutor's heroic and dutiful war hero father. It put before the jury new evidence highly favorable to the prosecutor. It exempted this new evidence from admissibility requirements and from the crucible of cross-examination, and most important, it equated prosecutor's father's noble sacrifice for his country with the juror's moral duty to sentence the defendant to death. They cite Ruiz versus State from 1999. Denigrating a defense mitigation expert for facts unrelated to his opinion in the case. They cite Campbell versus State from 1996. Comment on defendant's silence. Quote, the exercise of legal rights must not be used to enhance statutory aggravating factors. That was Bertinoli versus State from 1985. Right here. Arguing that life sentence would be a, quote, miscarriage of justice, unquote. They cite Brady versus State from 2012. See Sampson versus State from 2017. Future dangerousness, quote, a dangerous adult who was dangerous from the time he was a child and that he cannot be fixed, all of which suggest a pattern of dangerousness extending into the future, unquote. D. Hall versus State from 2012, and see Teffelteller versus State from 1983. Victim impact, quote, although the victim impact evidence itself was proper, the prosecutor's use of it in his closing argument, comparing the choices made by the victim and those made by Hayward, was improper. Quote, Hayward versus State, as revised on denial of REH''G, December 10th, 2009. Improper argument. Non-statutory aggravating circumstance, Robinson versus Moore from 2000. Receded from the other grounds, Mann versus Moore, 2001. Improper argument. The defendant had a, quote, character of violence. It cites Brooke versus State in 2000. Prosecutorial expertise, quote, I would submit now that the state does not seek the death penalty in all first-degree murders because it is not always proper, not always appropriate. They cite Brooks versus State from 2000. Based upon the foregoing, the defendant asked this court to direct the state not to make improper arguments in closing, and they signed it. So that is the documents so far that I have for Mr. Stephen Stearns that were all submitted January 30th of 2025. All of these documents are in reference to the homicide trial going on in September, not the CSAM trial going on here soon. Basically, they're throwing things at the wall to see what sticks, as Hio so eloquently explained it in our live. If you want to see where we talk about these documents and kind of break them down a little bit, she does a really good job of explaining it. It's in a live with the thumbnail of Madeline in a tutu, and it says breaking news, new documents we need to talk about ASAP. If you'd like that breakdown, again, basically they're trying to take the death penalty off the table. I really appreciate you watching this video all the way to the end. If you don't mind, please give it a like. If you have not subscribed, please do so and become part of the Speculating family. I really appreciate it, and I hope you all have a lovely night. Thank you again. Bye.